Waterboarding has been recognized to be torture since the time of the Spanish Inquisition. The United States had prosecuted American soldiers for using this technique early in the last century. They prosecuted Japanese soldiers for using it on Americans in World War II. But the two most recent nominees to serve as Attorney General of the United States hedged on the question of waterboarding. They would not say that if an American were waterboarded by some other government or terrorist anywhere in the world, whether it be torture and illegal. They maintain that it depends upon the circumstances. Do you agree with me that waterboarding is torture and illegal?
If you look at the history of the use of that technique, used by the Khmer Rouge, used in the Inquisition, used by the Japanese and prosecuted by us as war crimes. We prosecuted our own soldiers for using it in Vietnam. I agree with you, Mr. Chairman, waterboarding is torture.
Do you believe that other world leaders would have the authority to authorize the torture of United States citizens if they deemed it necessary for their national security?
No, they would not. It would violate the international obligations that I think all civilized nations have agreed to, the Geneva Conventions.
Do you believe that the President of the United States has authority to exercise a commander-in-chief override and immunize acts of torture? I ask that because we did not get a satisfactory answer from former Attorney General Gonzalez on that.
Mr. Chairman, the President has a constitutional obligation to faithfully execute the laws of the United States. There are obligations that we have as a result of treaties that we have signed, obligations obviously in the Constitution. Where Congress has passed the law, it is the obligation of the President or Commander-in-Chief to follow those laws. The President acts most forcefully and has his greatest power when he acts in a manner that's consistent with the congressional intent, consistent with congressional intentions and directives. If one looks at the various statutes that have been passed, it is my belief that the President does not have the power that you've indicated.
Well, the reason I'd asked that, just yesterday here in the Washington Post, you see it says detainee tortured. It says U.S. official. Trial overseer cites abusive methods against 9/11 suspect. Now, that's the convening authority for the military commissions, a top Bush administration official in charge of deciding whether to bring Guantanamo Bay detainees to trial, wouldn't refer an important case for trial because, as she said, we tortured the detainee involved. I'm glad to see we now have a nominee Attorney General who is unequivocal in this. Now, one substantive criticism I've heard of your position on important issues stems from a brief you signed on to before the Supreme Court decided the case of District of Columbia versus Heller. The Supreme Court has now clarified the law in that area. And for those who may wonder, the Heller case, the court recognized the personal right to bear arms guaranteed in the Second Amendment of the Constitution, expressly held for the first time that Bill of Rights includes this right among its guarantees of individual liberty and freedom. As I've told you, Mr. Holder, I am a gun owner, as a very large percentage of people in my state of Vermont are. My own home in Vermont, I enjoy target shooting, and before anybody asks, our nearest neighbor is over half a mile away, and it's our son. But do you accept and understand that the Second Amendment guarantees an individual right to bear arms?
I understand that. The Supreme Court has spoken. The amicus brief that I signed on to recited the history of the Justice Department's positions that had been taken prior to the Heller decision. Also expressed the belief in that amicus brief that was signed by a number of other Justice Department officials that it was our view, looking at the Second Amendment and looking at the applicable case law, that the Second Amendment did not confer an individual right. The reality is now that the Supreme Court has spoken, and that is now the law of the land. I respect the Supreme Court's decision, and my actions as Attorney General, should I be confirmed, will be guided by that Supreme Court decision.
Last year, for the first time in our history, this committee reported media shield legislation, a bipartisan 15-4 vote in the Senate. In the committee, this legislation provided qualified privilege, allows journalists to maintain confidentiality of their sources. And there are reasonable exceptions, of course, to prevent terrorism and protect national security and personal safety. If you're confirmed as Attorney General, will you work with both Republicans and Democrats on this committee on a federal media shield law?
Yes, I will, Mr. Chairman. It is my belief that a carefully crafted law to shield the press in the way that you have described is appropriate. Now, there are concerns that I'm sure will be expressed by people in the Justice Department. I want to talk to the career folks in the department. And I also want to ensure that with the passage of any law, that we will still have the capacity to protect the national security and to prosecute any leaks of intelligence information that might occur. But with those caveats and with the ability to interact with people in the department, I am in favor of the concept of such a law.
Now, you're very familiar with the Justice Department's Office of Legal Counsel. They're supposed to provide fair and partial, independent legal advice for the executive branch. Now, the press reports and our own hearings have shown that it's been used most recently to advance extreme theories of executive power. We've seen it in torture, warrantless wiretapping, and so on. Will you, if you're confirmed as Attorney General, commit to undertake a comprehensive review of all OLC opinions currently in effect and to correct and withdraw any that have what appear to be incorrect or problematic analyses, understanding these opinions really carry a de facto weight of law throughout the executive branch?
Yeah, I will make that pledge. It is important that these OLC opinions, which are so important, and as you describe, that they truly reflect what the law is, that they reflect our values, and I want to ensure that any OLC opinions that are in effect are consistent with those two purposes. Now, I'll do so respecting the fact that OLC respects the notion of stare decisis. We don't change OLC opinions simply because a new administration takes over. The review that we would conduct would be a substantive one and would reflect the best opinions of probably the best lawyers in the department as to where the law should be, what their opinions should be. It will not be a political process. It will be one based solely on our interpretation of the law.
Thank you. Now, some senators, following including commentators like Karl Rove, have spoken extensively about your role in the pardon of fugitive Marc Rich at the end of President Clinton's second term. In fact, I was very critical of that pardon at the time, notwithstanding the president's constitutional right to pardon people. Probably been critical of a number of different presidents use that constitutional right. You've also publicly said you wish you'd handle the issue differently. The details of this matter have been exhaustively hashed out in several congressional hearings. The Congress has spent millions of dollars looking into this. You appeared voluntarily and repeatedly to testify on the matter, something we haven't seen from officials of the current administration. So I want to give you a chance to address this suggestion by some that based on your actions, you are not independent. You will not be able to say no to a president who might nominate you. I have a two-part question to you. How do you respond to those who say the Marc Rich pardon shows you do not have the character to be an independent Attorney General? What did you learn from that experience?
Well, as I indicated in my opening statement, I made mistakes. And my conduct, my actions in the Rich matter was a place where I made mistakes. I've never said anything other than that. I appeared before 2 congressional committees and said nothing but that. I've accepted the responsibility of making those mistakes. I've never tried to hide. I've never tried to blame anybody else. What I've always said was that given an opportunity to do it differently, I certainly would have. I should have made sure that everybody, all the prosecutors in that case were informed of what was going on. I made assumptions that turned out not to be true. I should have not spoken to the White House and expressed an opinion without knowing all of the facts with regard to that matter. That was and remains the most intense, most searing experience I've ever had as a lawyer. There were questions raised about me that I was not used to hearing. I've learned from that experience. I think that, as perverse as this might sound, I will be a better Attorney General should I be confirmed having had the Marc Rich experience. I've learned that I have to ensure that there is full consultation with all the prosecutors who are involved in those kinds of matters. I can't assume that that in fact will happen. I have to make sure that it happens. I think we have to work to improve the pardon process within the Department of Justice. It appears that at the end of every administration there seems to be a deterioration in the process. And so I think we have to work on the Justice Department side to make sure that the rules and regulations are followed. It was something that I think is not typical of the way in which I've conducted myself as a careful, thoughtful lawyer. As I said, is something where I made mistakes and I learned from those mistakes.
And of course, the pardon was issued by President Clinton, not by you. But